So this is a webinar about the replacement for environmental impact assessment using so-called environmental outcomes reports. So I will cover what they are, when they're expected to come into force, comparisons with the new system and the old system, and a few suggestions about how you might be affected in various roles. Now there is a chat button and a Q&A button available to you, should be. If you could use chat for technical issues, I won't be looking at that. But Q&A if you have a question. I will not look at that either until I finish the first cut of the slides. And in the remaining time, I will work through any questions you've asked. And if there are any left over, we will follow them up, answer them in an email. This webinar is also being recorded, so you will be able to see it even if you couldn't make it or didn't make it at the beginning or whatever. Okay, so on with the show. Now, I should precede this with a massive health warning, because these proposals are currently in a bill going through Parliament, so things can change. They have got through their committee stage in the House of Commons. That's the first house considering the bill. That was on the 8th of September, reasonably recently, but they could still change. There was going to be a consultation about the detail of EORs, but that was going to come out this summer, and I was slightly gambling on that having come out by now, but it hasn't. But anyway, we will work with what we've got. There will then be regulations fleshing out the process. Those have obviously yet to be made because the bill hasn't been enacted yet. Then, to add even more uncertainty, on last Friday, the Chancellor, Kwasi Kwarteng, suggested in his accompanying documentation that there'll be a new planning and infrastructure bill that will, quote, minimize the burden of environmental assessments. So is that going to be a change to what is being proposed in the existing bill, or is it just re-endorsing what is going to happen in the existing bill? We don't know yet. Very early days, that was less than a week ago. You'll see a link on the screen, so when you get the slides, you'll be able to click the link, and you will get straight to any document that is referenced there. So what we are going on a journey of discovery. A lot of this is my best guess as to how it will work, because we just don't know, and maybe it's impossible to know because nobody knows yet. And I'm also assuming things are going to continue on a similar path to how it has been proposed so far. So what are environmental outcomes reports? Essentially, they are a new concept that will replace environmental statements in the next couple of years. The bill that they are contained in is the Levelling Up and Regeneration Bill, and they fill part 5 of that bill. That's a link to the current version of the bill, which is indeed the initial version, because committee stage hasn't changed it fully yet. Although the committee stage dealing with part 5 did not make any amendments to that part, so it survived committee stage intact. This is going to be a comprehensive change to environmental impact assessment. So this is a huge change if you were involved in big developments. So it's definitely something to keep close attention to, give close attention to, and monitor developments as it comes in. The whole regime is changing of environmental impact assessment. Clause 130 lists 18 consent regimes that currently undergo in EIA. The two biggest ones are the Town and Country Planning Act and the Planning Act 2008. But there's 16 more in there, like pipeline consents and oil and gas, and everything that has its own EIA regime is going to change. This is going to involve learning new concepts and new names for old concepts. And if there are any barristers there, I think case law is pretty much going to have to start again. This is a new British version of environmental assessment. will anything mean anything in previous case law? Probably not. So it's a real revolutionary change. Timing. So the bill is still going through Parliament. It probably won't finish till early next year. There was going to be a consultation coming out this summer originally, but obviously changes in not only the Prime Minister, but all the main secretaries of state means this has been delayed, and it might even not be this year. It might be the beginning of next year that this consultation comes out. The original intention was for them to become law sometime in 2 years' time, but I suspect that's going to slip. So let's probably assume it's going to be 2025. That seems ages away, 3 years away, but of course all these big projects, which by definition are big because they require environmental assessment, do have a long lead-in time. So you're going to have to start thinking about this at the early stages of a project because you may get affected by it later. So pay attention. The main new concept of environmental outcomes reports. So the big difference between EORs and ESs is that the EORs, ESs report on a rather static way on what the effect of a new project would be on the environment, what negative effects on various topics would be, and how these negative effects will be mitigated to make them as small as possible. EORs will be more dynamic. So instead of just statically reporting on what the state of the environment, they will report on the impact on efforts to improve the environment. So these are the outcomes. And over time, assuming the environment does improve, these can be ratcheted up and tightened over time. So it's much more dynamic and may reflect changing priorities over time. So one example I think is likely to follow through into the regime is air quality, because it is already outcomes based to some extent. So for example, there is a target to keep, or a legal obligation indeed, to keep annual average concentrations of nitrogen dioxide, just to name one pollutant, to 40 micrograms per cubic meter of air throughout the country. And it's currently the case that a project cannot make somewhere that is currently over that limit, that's currently under the limit, go over the limit, or somewhere that's over the limit, slow down achieving that limit as quickly as possible. And I think an environmental outcome will be very similar to that. Indeed, this one may just automatically transfer to being an environmental outcome. So if you are going to slow down achievement of that outcome, you're going to have to do something to reduce that slowing down. Or if an outcome has already been achieved and you're going to stop it being achieved again, then you won't be allowed to do that either. So if you remember one thing from this webinar, it is that environmental outcomes are tracking a dynamic set. Environmental outcome reports are tracking a dynamic set of outcomes rather than just statically reporting on the effect on the environment. So what are these outcomes going to look like? Well, we don't know yet entirely because they're going to be consulted upon, but there are some clues already. The one I mentioned of nitrogen dioxide and 4 other pollutants are one of the targets. These limits are one of the targets in the 25-year environment plan, which was published back in January 2018. It is reviewed every 5 years, so there should be one by January 2023, although I suspect that may not be achieved. Well, maybe it will be. Who knows? That's me, unfair of me. It hasn't not been achieved yet. There's a more recent page, less than a year old, which sets out all the targets that are mentioned in the plan. And this gives us a clue as to what the likely outcomes are going to be. There was a 2021 update that set out a lot of indicators, although those aren't really those aren't things that need to be achieved in the same way as the targets. So I think the targets are the things you should look at for a feel of what sort of thing we're talking about, rather than indicators. This is despite at the committee stage on the 8th of September, the Minister said, the outcomes will be fairly high level and user friendly, simply setting out environmental priorities. It will be the job of indicators underpinning those outcomes to measure the delivery towards the outcomes. But if you look at the indicators, they are, for example, emissions of greenhouse gases from natural resources. Well, that has no figure in it or target or anything. So I think targets are the thing and not indicators. Sorry, Minister. But even if we look at the current set of targets, a lot of them aren't particularly relevant to projects that are like to come forward. One of them is we will end the sale of new conventional petrol and diesel cars and vans by 2040. So unless your project is actually to build a new car factory that is going to make lots of petrol cars very cheaply or something, you're unlikely to be affecting that target. In fact, virtually no, I don't think any project will ever affect that target. Other targets are a bit vague in my view. So like maintaining the continuous improvement in industrial emissions by building on existing good practice and the successful regulatory framework. So how can you measure a project against that? I suppose if you're making industrial emissions worse, then that would not be maintaining continuous improvement in them, but otherwise it's a bit vague. So I think the eventual outcomes that you will have to measure against will be a much more tangible list, although some of the targets, like the air quality one, are tangible and will probably carry across. There is a helpful list in the 2019 update of which indicators are relevant to development, i.e. development projects. But unfortunately not which targets are relevant, although there is a sort of linkage between indicators and targets, but it's a sort of many-to-many link and it's a bit complicated. So moving on, what will an environmental outcomes report look like? I think it won't look too different from an environmental statement. So there'll be similar initial chapters describing your project, policy, and setting all that out. Then we get to the topics. These will be different. The groups of targets in the environment plan look like this as listed on this slide. And so I suspect the topic chapter equivalents will look like this as well. And you can see they're written in a rather positive way, improving sort of way, rather than just a neutral way. So instead of climate change, it's mitigating and adapting to climate change. Instead of air quality, it's clean air. Instead of waste, it's minimizing waste, etc. So I'd have explained one was reducing the risks of harm from environmental hazards. It's a bit difficult to work out what that's talking about, but in fact, it turns out to be flooding and coastal erosion. So that's the current list of topics. However, I think it is incomplete. The bill does commit to no regression on current EIA law, or at the time that the bill is enacted. And the Minister acknowledged that the 25-year plan did not cover everything already. So, and he cited landscape and cultural heritage as two that weren't in the plan, because of course, those are somewhat more aesthetic than environmental. And going to be quite difficult to specify outcomes. How do you improve landscape? I mean, if you can see your project, is that bad? Or if it looks nice, is that good? To be decided. I've also matched the environmental outcomes with typical EIA chapters, and a couple that notably seem to be absent are socio-economic and major accidents and disasters. So presumably something equivalent to those will be covered. What will a chapter look like? Well, the bill does give some idea of this. The mitigation hierarchy is set out in clause 117.4b as follows. Will your project actually make the achievement of the outcome more likely? Most projects won't, but there are some, like I'm working for National Grid carbon on CO2 capture pipelines, so they will improve impacts on climate change. So sometimes that will happen. But you probably aren't going to be in that category. I'm going to work through this with air quality on the next slide. The next thing in the hierarchy is, can you avoid the impacts on that outcome not being delivered? Then you look at mitigating effects that can't be avoided. Then there's a new concept called remedying the effects that can't be avoided or mitigated. Not quite sure what that means. And finally, back to the more traditional compensating for effects that can't be avoided, mitigated, or remedied. You have to go through all those. You also need to set out how you will monitor the delivery of outcomes, or the effect of your project on the delivery of the outcomes, and the reasonable alternatives that you considered to your project. I don't think the bill quite works in its current form, because obviously you're not going to propose a completely different option to your project, but you may have, the way it's phrased is a bit strange, so I think that may need to change. But alternatives is quite big at the moment in recent case law. Here's the worked example of NO2. So will your project reduce concentrations of NO2, i.e. help achieve the outcome? Probably not. Will it make achievement of the limit more difficult? If it will make it more difficult, can you change your project so it won't? If you can't do that, can you propose mitigation in addition to the project that will do that? If that will still not fully neutralize the effect of your project, can the well, I think remedying might be, can the negative effects be eliminated once they occur? NO2 might not be the best example, but could you remove the NO2 after it's emitted or something like that, equivalent of that on another outcome? Finally, if you can't even remedy the effects, can you compensate for your negative effects? That may not be appropriate for air quality, but in ecological terms, if you're harming a particular habitat, can you build a new habitat somewhere else that is better than the one you're affecting, or the effects you're having on an existing one? Then you'll have to list what monitoring is proposed to ensure this all works. I don't think it's going to be good enough just to demonstrate you're carrying out the mitigation you're proposing. You've actually got to show that it works as well. So I think that's going a bit further than existing environmental statements. There are some more familiar concepts. Just keeping an eye on time. Okay, we've got plenty of time. So for example, it talks about category 1 consents, which are mandatory ones that will have to provide the environmental outcome reports, and category 2 consents that will only have to provide them if they meet specified criteria yet to be set out. So that looks a bit like Schedule 1 projects and Schedule 2 projects, although it's talking about the consent rather than the project in this case, but it may end up looking fairly similar. Screening is not really mentioned, but it does say that it's more likely that EORs will be required than environmental statements will currently be required, suggesting the thresholds will be lower. But instead of going from nothing to a massive environmental statement, I think the idea is if you're a smaller project, you will have to do something smaller, and it'll gradually get bigger as your project has more effects. As I say, there's nothing currently about screening or scoping of what your environmental outcome report should contain, but these will look out for regulations later to see if that equivalents appear. There's also, as at present, you don't have to provide the mitigation you're proposing in your environmental outcome report, just as you don't in your environmental statement. It's up to the consenting body to require you to do that in the conditions or requirements they put in your consent. But monitoring might become mandatory, and there are enforcement provisions in the bill for if you're not doing what you said you're going to do, or if you're not achieving, or if you're damaging outcomes contrary to what you said you were going to. So have a look at Part 5 of the bill for more detail on that. So a brief comparison. So there's nothing equivalent to screening, but it's likely that the thresholds will be lower than they currently are. Nothing equivalent to scoping, i.e. what should be in my environmental outcome report. Can I ask somebody? One would hope there will be. Instead of significant effects, which are what you report in your environmental statement, you will be reporting on whether you are impeding these set of government declared outcomes. Residual impacts may be a thing of the past, but I mean, the idea is this is all going to, all your projects are going to positively contribute to the environment rather than have any residual impacts. But I can't see every project having no residual impact, so that might have to be, they might have to be compensated in some way, even if they still exist. Monitoring looks like it's going to be mandatory, whereas currently it's just what you're proposing in your environmental statement. So more emphasis at the delivery end, which was already the way things were evolving. So I've had a quick think about what this might mean for various professionals. Obviously, if you are a developer planning a big project, you do need to plan early, because you may need to, if your project is some years off, you may need to use this regime instead of the old one. And getting good advice, especially legal advice, but other professional advice is definitely recommended. If you're a third party, i.e. somebody affected by a project, one would hope that these environmental outcome reports will be easier to interpret and ascertain what they're doing to environmental outcomes. However, the traditional way of having some receptors and your impact on them may no longer be valid in an environmental outcome report, because it's all about these outcomes. So maybe it is more difficult to work out what the effect on any particular person or building or business will be. But one would hope this is going to be simplified and made more obvious. If you're a statutory body, you're often asked to give advice on areas of the environment in your domain. So you're going to have to think about it in a new way to match these EORs instead of ESs. If you're an environmental consultant, well, your whole job is going to change massively. Sorry about that. I am merely the messenger, but it'll be a real comprehensive change to your role if this really does happen as currently planned. If you're a solicitor, your advice on major applications will change quite a lot, because a lot of it is about environmental impacts and how they are guaranteed in the consent and that sort of thing. Like DCOs have an awful lot of legal implications during their examination, preparation of applications and afterwards. And barristers, as I said, we're going to have to really restart case law, perhaps. A lot of EIA case law is on, does my project need to undergo EIA or not? So that threshold looks like it's going to be lower. And so all the existing case law may have to be thrown out the window. Right, this is my final slide. So I did rather rattle through those because of the late start. Sorry about that. So I'll take a look at the questions just after I've set out what I think the next steps are going to be. So a consultation will come out at some point. It was going to be this summer. It may be later this year or even early next year. Obviously, just like on biodiversity net gain, although it was asking questions, it did give a very strong indication of what the government was thinking about how this would all be done. So not only responding to the consultation, but reading it and how it looks though it's going to work is obviously vital. Well, there will be consultations on setting the outcomes as well. That list back on a previous slide of clean air, etc. So if you're involved in any particular topic, or maybe if you're doing a big project, you might have to look at all of them, get involved in those consultations. Once the bill is enacted, there will be regulations underpinning it, which will have all the detail and the process and all that. And obviously the most important thing is to keep in touch with us. There will be future events, no doubt, on EORs as they develop, and we'll be sending out briefings under our various blogs and newsletters and so on. So do sign up for those if you haven't already. In fact, we'll probably badger you just for attending this webinar as well in the future. Right. I've put on this final slide, I've set out the links that I previously had in amongst the other slides. So let's have a look at the Q&A. I've now got 17 questions, so I'll get through as many as I can before 11 o'clock. And I will answer, as I said, answer the others in writing and send those out. So this is a nerve-wracking bit because I'm just going to read these out and, without having any notice of them, and see what I can do. So first question, the draft DEFRA statutory long-term environmental targets, March 22 consultation, do not match the interim environmental targets in the 25-year plan. This seems to be an issue. Should defined environmental outcomes for this regime use statutory targets or policy targets? Surely statutory targets trump policy ones. There may well be a mix of statutory and policy targets. So the air quality targets, for example, are statutory. They're in the air quality regulations. But the fact that those have to be achieved by 2015 or whenever it was, and they haven't been, doesn't really mean that they're having a sort of really strong effect. The new Office for Environmental Protection is going to be, no doubt, looking at these targets and commenting on them. It has already expressed concern about this change in regime, and looks though it's not going to take its job lightly or be a pushover. So this is the replacement essentially for the European Commission, which monitored member states' compliance with the EIA regime. The OEP is going to be doing that within the UK, and certainly isn't going to suffer fools gladly by the look of it. So question is, yes, there will be statutory targets outcomes, but there will also be some policy ones that are not underpinned by statute, I would guess. Where did the government confirm its intention to bring EORs into law by 2024? That isn't written down anywhere. That is just what I've understood from talking to officials. But events conspire to mean these things take longer anyway. So I think it probably not be until 2025. We also need to see what's in this planning and infrastructure bill that has been promised, or even when that comes forward. Will that make all what I've said a load of old rubbish, or will it carry on? I hope it carries on. Otherwise, all this uncertainty is going to be very unsettling for everyone. This transition seems unnecessary and poorly thought out, more of a political distraction fueled by lobbyists. Is that just me? I don't know about the fueled by lobbyists. I mean, I think this is somewhat motivated by having domestic environmental law rather than European environmental law. So that is an opportunity to recast it. Is the EIA regime working? It is to some extent, but environmental statements are just getting bigger and bigger. So perhaps it is a good time to just sort of reset and start again with smaller ones. So I won't make an opinion on that. Have you considered what are the advantages of the new EORs and the potential drawbacks compared with the current ES process? Well, I think the advantages are it'll be more dynamic. So if something new, we discover some new pollutant, then we can easily fix the outcomes so that microplastics, if we've decided that they're going to kill everyone, then we can just immediately put those in as an environmental outcome. So I think that is more dynamic, and as time goes by, the WHO, for example, are already tightening air quality targets. So over time, I can imagine the air quality ones will be tightened for certain pollutants. So I think that is an advantage. Drawbacks, well, we've got to just handle a new regime, and it's going to be very difficult to change one's mindset from what has been established since, when did EIA come in? 1988 was the first directive, which is a long time ago. We've had to get used to this. So just the change, it creates uncertainty, but I am an optimistic sort and see changes as opportunities, so I hope things can be improved. I was wondering if through this reform, the standards used, i.e. DMRB, that's Design Manual for Roads and Bridges used by National Highways, will be able to keep up with the changes and not cause more confusion to an already complex EIA process. Well, that's certainly a good point. I think a lot of documentation, satellite documentation produced not just by the government but by others, depends on the way EIA works, and so may have to be recast to this new regime, and that's going to be quite a process. So we do need a reasonable gap between knowing what the regime is going to look like precisely and it actually coming into force, so that all the documentation like the DMRB can be recast accordingly in time, without being done in a rush when it will be done badly. How do you think they will enforce mandatory monitoring, particularly for long-term outcomes such as biodiversity net gain? Well, biodiversity net gain is a whole other regime that is in a different act, the Environment Act 2021. Although obviously it will have to fit in with EORs as well. There is an enforcement regime that in the bill that you can have a look at. It's quite like planning enforcement. So local authorities and others can step in and rectify things and then charge developers for if they don't do it themselves, that sort of thing. It looks quite like planning enforcement, but have a look at the bill for more details on that. Is there any indication of the level of baseline data required to support the assessment of environmental outcomes? E.g., much of the perceived burden of the current approach is the need for extensive baseline data to evidence the assessments that are made in the ES. Well, that is going to be a big issue, baseline data, because it's data against these dynamic outcomes instead of just the static environment. So I think baseline data may need to change, but I don't think there's much information about that yet. Hopefully the consultation will flesh out that to some extent, I'm afraid. Is anyone aware, well, of the justification / needs case for the proposed reforms? There doesn't seem to be any explanation for what they've proposed or why they proposed it. Well, there is some explanation. If you look at the original justification for the Levelling Up an Environment bill, I mean, it does talk about Brussels imposed targets, so there's a bit of ideology in there. But I think it is, I think after so long, environmental impact assessment is in need of reform to some extent, although it was even by the EU about 5 years ago reformed, where they added things like major accidents, disasters, etc., climate change, greenhouse gases. But I think the needs case is fairly thin at the moment, from what I've read. Will EORs replace ES addendums for projects that have already submitted an ES? I think that's unlikely. I think there will be some transition, and a project that has reached a certain stage will continue all the way through under the existing regime. It won't have to switch. it may be at the point at which you make an application, or it may be even earlier. If you've, say, got a scoping opinion that you do need an ES, you might, but that has yet to be set out. But I don't think any project that has at least made an application will have to change regime halfway through afterwards, if once the new regime comes in. What are your thoughts on a move towards digital EIA from the LURB? Well, digital EIA is yet another change to all these regimes. Everything's changing at once, which does make us all a bit unsettled, I think. But again, digital is a good idea. My vision is that you'll be able to put in your postcode into some digital document and it'll tell you what the impacts are on you. But how will that work with environmental outcomes? Maybe it'll say whether an outcome is, it'll go through the hierarchy for you, whether the outcome will be improved in where you are, or what mitigation is proposed if it's not going to be improved, and then what compensation and so on. We'll see. But in a way, it's good to have a comprehensive change, but in another way, to change everything you know and hold dear all at the same time makes it even more uncertain and may affect even investment in projects. So we have to be done very carefully over a long period of time, so that all unintended consequences can be worked out and anticipated and dealt with before the regime comes in. Can you confirm that this will apply to marine licensing through Marine Works Regulations 2007? I'll have to look that up, but everywhere that EIA applies, this new regime will apply. It's in that clause 117 I mentioned. How are we doing for time? We've got 8 minutes, 41 questions. As I say, I'm also not letting you see the questions, I'm afraid, because once I click the answer live button, it disappears from my list. And so I'd rather answer all of them in writing to you all later, as well as this oral answer of as many as I can get through. What are your views on the level of information and evidence that may be required to support the decisions/findings in the EOR? For example, is it likely that assessments and surveys, as currently undertaken as part of the EIA process, would still be required? I'm pretty sure, yes, you will need surveys and assessments. So if taking air quality as an example, you will need to check whether your emission, you are going to emit nitrogen dioxide that will slow down achievement or breach current achievement of that 40 micrograms per cubic meter target anywhere that your project might have effects. So I'm pretty sure that will carry on. Surveying, it may have to be slightly redescribed. Any thoughts on grandfathering rights on existing legislation, and when and how these might be phased out? Well, as I say, there will be transitional provisions. I think it's very unlikely that a project that has made an application will have to switch regimes. They'll have to, and it may be even earlier stages than that will apply. So, I mean, that's based on evidence of any other changes have always been only on new projects, not existing ones. Whilst I'm an ecologist, so support high environmental protection, any idea how this actually removes regulatory requirements / red tape, etc.? I don't think it's intending to remove regulatory requirements, because indeed there is a non-regression clause that says it can't make protection of the environment worse. Governments always love removing what they call red tape. And I think it's going to be very difficult to set these outcomes so that initially they will have roughly the same effect. Because if you set them too globally, then any project, just like with climate change, where it says, if you look at recent DCO decision letters, they say this project will affect the 6th carbon budget by 0.001%. I mean, if it's a national target, any project is going to have a tiny effect on it. So every project will argue they're not really affecting a national outcome. But if it's a very localized outcome, then every project will affect those. And so that'll be much harder than the existing regime. So it's got to be somehow fixed in the middle, so that it's the environment, the regime bites but does not stop all projects, and but does not let all projects through either. That is the real challenge. Great talk, thank you. Thank you. Could you please return to the slide on the various new chapter titles proposed? Oh, I can do that one quite easily. You will get these slides, don't worry, that's the one. It doesn't say these are chapter titles. This is only my speculation based on the environment plan. But it does group the indicators in this way and the targets. If a project starts with the current EIA process and then, yeah, I'm getting a lot of the same questions, so that I think I've already answered that one. So apologies for not saying that in the first place. How would the EOR regulations compare to the SEA regulations in terms of the requirement for assessing reasonable alternatives? Yes, I should say this will apply to strategic environmental assessment as well as environmental impact assessment, incidentally. I haven't made that clear. There is something in the bill about alternatives. As I said, I don't think it quite works, but you will need to show that you have thought about alternatives that have less impact on these outcomes, just as you do currently. Well, not exactly as you do, but alternatives will feature certainly in this regime. You always have to be careful with alternatives, because if you're a landowner, you can't just suddenly build something somewhere else, because you're only going to be able to build your project on your own land if you're applying for a planning permission. Or if you're applying for a DCO, you're more likely to build it on your land, even though you have compulsory acquisition powers. And if you're building a road, you're not going to say, oh, a railway would have been better, are you? So alternatives, you have to be very careful not to require everyone to build the best possible project, otherwise nothing will ever get built. But you do need to show that you have considered some alternatives. Okay, I've got 2 minutes left. Probably time for one more answer before I wrap up. If assessment is to be against stated outcomes, does this mean that planning policy will move towards defining outcomes rather than process? Is planning policy currently concerned with process? Well, there are other things in the LERB, like national conditions, essentially. Oh, sorry, national policies that would otherwise be repeated in local plans all over the country. They're somewhat controversial, but they're supposed to be slimming down local plans. So I think they are trying to move towards actually engaging on the issues that planning developments throw up, rather than the process. So the LERB does that in various ways, not just this way. Will you share your slides? Yes, I will. Okay, I think I'm going to have to stop there because it's 1 minute to 11. Thank you very much for attending. I hope that was useful. I've had 44 questions, so I will endeavour to answer them in writing. In fact, I'm going to quickly capture all the questions before they disappear in case Zoom makes them go away. Thank you very much for attending. I hope that was useful. I apologize for the Zoom issues at the beginning, but watch this space. We will keep you informed, as no doubt will other environmental professionals. There's lots of detail to be filled in. Thank you for joining, and keep in touch, and we will keep in touch with you. Thank you very much.